Good evening. My name is Krista Bowe, and I'm an academic advisor for the TRIO Student Support Services Program. And I'd like to welcome you all to today's Wolf Talk. This Wolf Talk speaker series is sponsored by TRIO Student Support Services and Student Involvement in Leadership. It focuses on leadership, social justice, community impact, and held in conjunction with our common read. Today's speaker is Judge Tony Portra from the South Dakota 5th Judicial Circuit. Judge Portra is an Aberdeen native graduating from Central High School. He received his undergraduate degree from Moorhead State University and his Juris Doctor from the University of South Dakota. He was appointed as magistrate judge in 1999 and elected as circuit court judge in 2006 and 2014. He is the chairman of the South Dakota Judicial Ethics Committee and a former adjunct instructor here at Northern State University. Judge Portra and his wife Jamie have 2 children. Please help me welcome the Honorable Judge Tony Portra.
Hello. Does that sound okay? Is it too loud or? All right? Okay. Sounds loud to me. Well, good evening. I'm happy to be with you tonight. I've been looking forward to giving this talk. As you heard, I'm an Aberdeen resident and obviously came back home to work and start my family. I did take a couple of classes at Northern as well in the summer, so I guess that doesn't qualify me as an alumni, but I'm proud to say that I'm from Aberdeen, and Aberdeen's been pretty good to me and my family. I'm a circuit judge, and I don't know how much you've talked about the different levels of the judicial system in South Dakota, but we have magistrates, circuit court, and then the South Dakota Supreme Court. We don't have any intermediate courts of appeals, and we don't have any courts such as, we don't have a special family court, we don't have a special court that handles only juveniles. We have our circuit judges are considered judges of general jurisdiction, so that we handle every type of case that you can think of. And getting close to 18 years on the bench at this point, I've handled just about every kind of case that you can think of. I don't prepare a lot of notes when I come and talk to people. I like to have it just be a conversation. I think it's a lot more natural that way, and hopefully you'll ask me a lot of questions. And then I find out what you're interested in, and then we can talk about what you want to talk about. And it kind of also helps me kind of get the level of the room, what you know, what you don't know, and helps us go from there. I certainly can sit and bore you and just talk about my job all day, but I would rather hear from you what you want to talk about and hear questions. What a typical day might look like for me, I printed off a copy of my calendar, from Tuesday. And Tuesday I went to Redfield, and that was a pretty typical day. Other than sitting in Aberdeen, I handle court in Redfield twice a month and in Falkton once a month. In Redfield on Tuesday, we had, that seems really loud. Does that seem loud to you guys? I'll try this a little lower. We had 38 cases on the docket that day, and those were all different kinds of things, a lot of criminal cases. We've had everything from a change of name to a small claims case. And the most serious case that I handled that day was a Class C felony. A Class C felony means up to life in prison. It was a fairly interesting case. It involved a 17-year-old boy, I guess you would have to use the term at that time, who had sex with a 12-year-old girl. That is considered first-degree rape, so he was looking at up to life in prison. Just so you know, I did read the book, Just Mercy, so I tried to make some notes on some things that I handle that are similar to some of the issues raised in the book. In the book, he talked about juveniles being tried as adults. In South Dakota, because of the level of the offense and his age, he would be presumed to be an adult, and he would have to try to petition the court to come back to juvenile court. He did not try to petition the court. By the time he got, when the offense happened, he was 17. By the time he got charged and actually came to court, he was 18 years old. So he and his attorney did not try to come back to juvenile court. Clearly, it was a very serious case. He's looking at spending the rest of his life in prison. I just want to, if I could take a moment and kind of share with you some of the things that, what we did was we had a plea, and then we did what was called a pre-sentence investigation. That's where the court service officer, you might know them as a probation officer, does a report, tries to gather all of the information available and give it to the judge, and the attorneys as well, of course, to give the judge as much information as possible in making that decision. So here's some of the things that the child had to say regarding this. This has affected me in many ways. I felt depressed, alone. It made me feel worthless. But it didn't just impact me, it impacted my family as well. I now suffer from depression, anxiety, and post-traumatic stress disorder. I don't sleep very well because I have nightmares. I used to try to harm myself as a way to cope, but I don't anymore because of all the intense therapy. She goes on to talk about different things. She says, I don't like physical contact very often due to being raped. The mom in her statement said, that day will haunt me forever. I took my children on what was supposed to be a fun weekend away to see close friends instead of a weekend filled with fun memories. It has left me broken-hearted, angry, hurt, and full of what-ifs. That night, the defendant raped my 12-year-old daughter. Before my daughter was raped by him, she was a regular 12-year-old little girl with a zest for life and a smile that could light up a room. She was happy, loving, caring, funny, full of life, enjoyed school, straight-A student, and enjoyed hanging out with friends. She loved playing basketball, diving, and being outdoors. The night he raped her, it changed her. She is no longer carefree, fun-loving, or full of life. She completely changed her appearance, started failing classes. The sparkle in her eyes were gone. I knew something was wrong the next day and months to follow, but I never fully knew until she had the courage to finally come forward to her father and I. So, according to the mom, what happened is this 12-year-old little girl was just normal, happy, carefree, and she says it was like a switch flipped in her. And the mom describes her being hospitalized, cutting herself, trying to kill herself, being diagnosed with post-traumatic stress disorder. Most recently, the therapist indicated that she may have bipolar disorder that was latent but triggered by a traumatic event. And this was just one day in tiny Redfield, South Dakota, along with 38 other cases that were on the docket that day. These are cases and dramas that are acted out every day in the courtrooms that we preside over. It's not some, story on Special Victims Unit, Law and Order, or some other movie. These are people with real life issues and real life tragedies that are happening in court every day. And so what do you do with someone who is facing up to life in prison, who's 17 years old, now 18, who's had sex with a 12-year-old girl, who has no prior criminal history, who has pled guilty and taken responsibility and said, just taken responsibility for their actions, but yet has committed such a terrible, terrible crime with unspeakable consequences. What are your thoughts? I can tell you what I did, and it kind of has a footnote to it, and I'll explain that. But what do you think? Anybody have a thought, an opinion? they disagreed in the pre-sentence investigation. They clearly weren't in a relationship. There were two different scenarios that were presented. He says that she came to him and started it, and that he didn't stop it. He refers at times to what we did was wrong. She says that he came to her and he forced himself upon her. And I thought, the book was very good, especially the book that I liked a lot, the part about Walter, the main case that he talks about, the guy getting off death row. I disagreed with the author sometimes when I would say what I would call getting on a soapbox about how harsh we are to juveniles. I don't see that, and that's not my experience. Now, I'm not saying he's wrong. I'm saying that's not my experience. But this person was a juvenile when this happened. But there's always two sides to the story that you can see. On the one side, you see that he doesn't have a criminal history, that he's young, that his brain, according to the research, isn't fully formed yet and probably won't be until he's around 25 years old in a typical male. We know that on his side, and those are arguments that we make on his behalf. But then, what about that changes how devastated she is? Does his age change how she wanted to kill herself? Does his lack of criminal history make it so that she doesn't have nightmares anymore and doesn't, have these thoughts of self-harm, depression, anxiety? So we see this on the other side too. When somebody has an alcohol problem and they're driving and they run into your car, your loved one's car and kill them, you understand from their standpoint that they have a disease that they're trying to deal with, but yet is your loved one any less injured or dead? If that person is the sole provider in your household, does that change? Does that somehow, do you have money now because this person has a disease? And the answer is, of course, no, you don't. So there's two different perspectives always that we have to look at. And of course, the state's attorney, their normal job is to argue one, and the defense attorney the opposite. Yes? Yes? Yep. We do ask questions because we have to establish a factual basis. From time to time, somebody will plead guilty to something that doesn't meet the technical definition of the crime. I'll inquire with them, and that's very rare, but it has happened to me, where they tell me what they did, and I say, okay, explain that further. They say, well, that really doesn't meet the elements of the crime. So we have to ask questions to get a factual basis, meaning do the facts meet the elements of the crime? Now, in this particular case, we didn't go into the consent issue all that much as far as a factual basis because consent isn't an issue. She's not old enough to consent, whether she said yes or no or what have you. It doesn't matter as far as the plea is concerned, because even if she was the most willing participant, he still has committed the same level of crime, but then those facts would be more relevant as we look at sentencing and we decide how bad it was. Does that make sense? Yeah. Yep. So that it didn't really become an issue, because even if at the plea part, the plea stage, it didn't become an issue, because even if she said yes, she's not old enough to say yes. So we addressed that more in the sentencing. So does anybody else want to share a thought before we kind of talk about what happened in this particular case? So what happened was the state's maximum life in prison. There's a mandatory minimum of 15 years in the penitentiary unless the court finds good cause to go below the minimum sentence. The state's attorney and the defense attorney brought to the court a plea agreement where it would be, the sentence would be 15 years with 5 years suspended. So he would be sentenced to 10 years in the penitentiary. He would serve 5 years before he'd be parole eligible. I asked the victim's mom to come forward and provide a statement. She told the defendant exactly what he had done to their family and how it had affected their family. At the end of that statement, I specifically asked her whether or not she agreed with this disposition. Is this what she wants to have happen? Because I was not prepared to pronounce that sentence if she did not agree. She told me that she did agree, that she thought that's what should happen in this case. And given the fact that the state's attorney, the defense attorney, and the victim's family had all asked me to enter that disposition, that is the disposition that I entered. I gave him 15 years in the penitentiary with 5 of those years suspended. By our law, he would have to serve 5 years before he'd be parole eligible. So it was a very heart-wrenching case. It's a very interesting case. I wish it was a more unusual case, but unfortunately it's not terribly unusual. At the end of the case, you never know if you're doing the right thing. Generally, if all of the parties agree, you tend to think that that's probably the right answer. At the end of the case, the victim's assistant was getting ready to help the victim and her mom and their family members leave the courtroom, and she said, "Judge," and I looked up and the little girl was crying and she said, "Thank you," and then she filed out and the mom said, "Thank you." So I don't know. I guess they were satisfied with the outcome of the case. That's what they wanted to have happen. And I told that defendant, you better, when you're sitting in that cell, you better remember the grace of this victim and her family, because but for that grace and but for their thoughts on this matter, you would be sitting in that cell for much longer. So that's what happened. So what do you think? Is it too harsh? Not bad enough? Should be more? It's tough calls. It's a very serious matter and very serious damages in a very young man with no criminal history. Now, his family was a little bit interesting. His mom and dad had been married for quite some time. Recently, they had become divorced. I had seen his mom in the past weeks. She had been charged with prostitution as well as possession of controlled substance. They seem like a fairly interesting family. I don't know how much of that dynamic played into it. Like I said, they had been married for quite some time prior to that. So I don't really know what his upbringing was like. I know that in the recent past it wasn't good. So that was that case. And then we just had to do the 37 others, and then we were done with court for the day. And I wouldn't pretend that they were all like that. Sometimes the attorneys just tell me that they need a little more time, they're working on something, or they need to get some more information from the other side before they're ready to go forward. I had one case was on the same day that was a bit unusual and absolutely no playbook for this one. A guy had gotten sued for not returning 2 movies like 6 years ago. And they took him to small claims court for the cost of movies. The movies were about $40. Well, he didn't respond. He didn't answer in any way. So the case went to a default judgment, and for every day they couldn't rent the movies over like 2 years, they charged him whatever fee they could have got for renting. So he got a judgment against him default. I mean, I didn't even see it because it just went to a default, and the clerk signed off on it because it was small claims, for $2,400. Now he was coming to the court, the judgment was up to $4,000, and he was trying to get financing to buy a house or something like this, and it comes up on his credit report that he has this judgment of $4,000, which he just totally blew off, over these 2 movies. And his attorney comes in and says, "Judge, I mean, come on, this is not justice to pay $4,000 for 2 movies. Yeah, I have some sympathy for you. On the other hand, you could come to court and, act like a responsible adult and take care of this and, get whatever judgment, that was actually owing at that time, what would have been fair at the time, and just pay the judgment and be done with it. So, I mean, what do you do in that? That's an unusual case. What do you do? I said, the plaintiff had $40 in filing fees. I said, come up with $240, pay her by the end of the day, and I'll vacate the judgment. She's owed something for her time and trouble, but I don't think it's $4,000. And he went to the cash machine and got $240 and brought it back to her, and that was that. So I just kind of made that one up on the fly. There's really, there's no judge's book where I can check and see what you should do in that case. It's just an odd little thing. So I decided what I thought was fair, and so he had to pay his $240. Let me see if there was anything else interesting on that day. Mostly just minor criminal matters. A divorce, a change of name, nothing that exciting. Today, like I said, unfortunately, that girl that we had the serious case in Redfield on Tuesday, today, of course, is only Wednesday, and I accepted another plea from a gentleman for digitally using his fingers to penetrate the vagina of a girl who was 11 years old. That is also a Class C felony. His plea agreement is the state agreed to cap their request at 50 years. He was ordered to do a psychosexual evaluation and have a pre-sentence investigation be completed, and then he'll come back at a later date for sentencing. He obviously was a much older individual and had a lot more criminal history. And of course, there were many other charges that the state could have brought involving in other matters that they dismissed or didn't bring as part of this plea agreement. So his sentencing is for a later date. We have to get a lot more information. But like I said, I wish it was those cases were uncommon and almost never heard of in Aberdeen, but unfortunately they happen all too often. Some of the other things that I do in my job besides just criminal law, I handle DUI court, which is a new thing to South Dakota. It's a specialty court. We handle just about 15 people that have habitual driving under the influence. Convictions, these would be people that normally in the past would have gone to the penitentiary, people definitely with addiction issues. They're under intense probation. They get a lot of mental health counseling, chemical dependency counseling. Court service officer, instead of having 50 people to monitor or 70 people, they only have 15, so they can spend a lot more time with them. There's a lot of restrictions on where they can be employed, who they can hang out with. And basically, we're just nosy and we get into every aspect of their life. And we've had some great results. Some people go to DUI court and they just think that basically they're just going to try to stay out of the penitentiary as long as possible, and they really don't have any intentions of changing. And then we have other people who have every intention in the world that have had issues in their past that they couldn't overcome, but never had this type of support. And with this intense treatment and intense supervision and support, can do just excellent. And so that's a new program. We have both a DUI court and a drug court now, and that's a new specialty court, which I think we're 3.5 years or something like that into our DUI court, and only maybe 6 months into our drug court. And I've been presiding over the DUI court for roughly 1.5 years. So that's a new challenge and something I hadn't dealt with before, but it's also very interesting. I handle all of the juvenile cases and the abuse and neglect cases in Brown County. Again, those can be challenging. You're dealing basically with whole families because a lot of times the reason that the juveniles are having issues and acting out is because of what's going on at home. And so you have to deal with the parents as well. It can be particularly challenging because the parents don't always want to be dealt with. A lot of times the parents have the attitude, well, you know, Jimmy's the one in court, it's Jimmy's problem. Well, there's probably a reason that Jimmy's here, and maybe we need to, regardless of whose fault it is, we either all work on it together to get Jimmy better, or Jimmy doesn't get better. So there's been some challenges with that. I don't know if anyone, Justice Gilbertson or anyone else has talked to you about Senate Bill 73, which is the juvenile justice reform, which has taken away a lot of the power of the court to do a lot with the juveniles. And so that has handcuffed us quite a bit in what we can do. That has been extremely challenging and frustrating for a lot of the probation officers as well as a lot of the judges. So it's interesting. I feel like we're kind of in the middle of a big social experiment. We're all just trying stuff and we're going to see what happens. And we won't really know the answer for a few years down the road. Like any experiment, you don't know during the experiment how it's working. But it's been very challenging. Any questions about any of that stuff, about handling abuse and neglect cases or juvenile cases, criminal cases? You guys are making me do all the talking, you know. I told you it'll be more boring if I do all the talking. I'm sorry? I guess the most common thing that I see would be the common theme is alcohol and drug abuse. If you talk to, in fact, we had the judges conference here in Aberdeen a couple weeks ago, and some of the members of the drug task force in Brown County did a presentation to all of the judges. They'll say, you know, if you have possession of a controlled substance or drinking and driving, obviously that's a drug and alcohol issue. If you have a robbery, that's a drug and alcohol issue. If you have burglary, that's drug and alcohol. If you have assault, that's drug and alcohol. Abuse of a child, probably drug and alcohol. That's the common theme that runs through everything that we do, probably 80, 85, 90%. You know, people are stealing to get drugs. They're fighting while they're drunk. You know, it's just a common theme. Lots of you know, charges of possession of controlled substance or ingesting, meaning using the substances. You know, I see a fair amount of felony DUIs. If you do magistrate court, there's always lots of DUIs, disorderly conduct, underage drinking, simple assault, you know, all of those types of things. But there's the one theme that always goes through everything is alcohol and drug abuse, because that's either the elements of the crime or it drives the crime. It's why the crime is being committed. Methamphetamine is a huge problem in Aberdeen. It's a huge problem in a lot of places. You know, these police officers show the videos, and, you know, at times people talk about these drug crimes as being victimless crimes. Watch the video. Watch when the officer goes in and sees the 8-year-old little girl and says, "What's going on here? Mommy won't wake up." You know, or you have 3 kids, you know, one's 11, one's 7, one's 2. The 11-year-old is raising the other 2 because of alcohol and drugs, because there's no adult to do it. The 11-year-old is the one getting the kids up, trying to get them ready for school, trying to make sure that they have something to eat, if there's anything in the house to eat. It's unbelievable. When you talk about victimless crimes, you have to look in the faces of those little kids and find out if it's victimless or not, because they're living that hell every day. And then we're trying to figure it out, and we're trying to sort it out as a criminal justice system, and we're not very well equipped to do that because we're not social workers. So I don't know if I answered your question very well, but as far as a specific type of crime, but definitely there's a theme that's woven throughout the crimes. Other questions? Yes? Strange, I brought with me a letter today that was kind of strange and kind of humorous, and it has some interesting language in. I asked Krista if I could share it, so we may get to that, as long as it's not too inappropriate. But it was something that was sent to me by someone in the penitentiary, so kind of an interesting character. One of the most interesting cases that I dealt with happened 6 months into my tenure when I was still a magistrate judge. I went out to Selby to handle court in one August day when I had become a judge in March. This was August, so it was 5 to 6 months in. And I was just going to go out and do magistrate court because the judge out there was on vacation. And so normally magistrate court, again, bad checks, simple assault, drinking and driving, underage drinking, that kind of thing. I'm literally pulling into the parking lot and I'm listening to the radio station in Mobridge because that was the only thing I could get. And they say 4 teenagers charged with murder are going to appear in court today. I went, okay, no one really mentioned that to me. It happened overnight. They were just finding out about it. So I get there, small town sheriff says, here's your bulletproof vest, put it under your robe, here's your walkie-talkie, and you can call if there's trouble. What made it more interesting is that the victim is Native American, the 4 defendants are white, and it was explosive from the very beginning. What happened was, as eventually the evidence comes out, what happens is all 5 of them know each other. They're friends. They go out drinking. It's a couple months after graduation. It's the summer before they're either, going to college, getting jobs, whatever, and they're out partying in the summer. Not too unusual so far. The victim gets so intoxicated, he passes out. They can't wake him up. So the other 4, which I'm sure none of them should have been driving, take him home. And they pull in the alley because they don't want to get caught. And instead of just letting him out and taking him to his house or whatever, they put him in a garbage can, upside down. And their testimony was that they thought this was going to be so funny. He's going to wake up and he's going to go, oh my gosh, I was so wasted. That was the best party ever. I mean, this is like a legendary story. He didn't wake up. His blood alcohol is 0.446%. So we have a preliminary hearing, and a preliminary hearing is a hearing where magistrate decides whether or not there's enough evidence for these charges to go forward or not. Is there enough to even go to the trial? The doctors come on the stand and they testify that this gentleman had drank so much alcohol, it didn't matter where he was, it didn't matter if he was upside down, right side up, laying in his bed, it doesn't matter. He drank himself to death. That's the evidence. That's the only evidence that's presented to the court. I have no choice. I have to dismiss the charges. The state has not proven that they did anything. They're charged with murder. In order for them to be charged with murder, they have to have done something to cause his death. If he drank himself to death, if I'm to believe the doctors, there was no other evidence that was presented, he drank himself to death through voluntary intoxication. I know that that's not going to be received well. So I took my time. I wrote about a 10, 15-page decision in explaining my rationale and my reasoning. Interestingly, no one ever really attacked me as far as my reasoning that I didn't make the right decision based on the evidence that was presented. But people were very upset at the prosecutor and law enforcement that they didn't bring forth any other evidence. Now, I don't know if there was other evidence that was there to be brought. I don't know. But they didn't bring it forward. This case went on 2020. This was a national news story, and this was 6 months into my tenure as a judge. It was explosive. and they ripped the prosecutor and law enforcement pretty good. They left me alone, thankfully. But it was a very hard case. I mean, it was one of those cases where I thought, I still feel I did what the facts and the law told me to do, but I didn't feel good about what it did to race relations in Selby. I didn't feel good about the way they treated him, whether it was his live body or dead body. The way the callousness, what they treated with another human being. But I can have all those personal feelings that I want. If the state cannot prove that they killed him, did something to cause his death, then that's what I have to find. So that was one of the more interesting, challenging cases that I had right off the bat. Is there another question, another hand? Sir. 150 years. It was actually 3 50-year sentences, but I ran them back to back to back, so it was 150 years. Actually, to the gentleman who was the subject of this letter that I received. He had raped his granddaughter multiple times in multiple ways. Appointed an attorney to represent him. We went to trial. He was convicted at trial. He was very upset with me that I would not let him show his penis to the jury. His theory was that the way the victim, I can't remember exactly, I want to say she was around 10, that she had made comments like when describing the incident, something about that it was squishy and had a funny tip, something like that. Pretty nondescript. He contended that I don't remember if it was, he contended that was describing a circumcised penis and he was uncircumcised or vice versa, but either way, he said it described one kind of penis and he had the other kind of penis, okay? And frankly, if I thought that she had described it specifically enough that it did say one or the other, I would have allowed him to do it. It's extreme, and I would have given some cautionary instructions to the jury, but I didn't think there was anything that the juvenile had said that really described it one way or the other, so that it seemed to me that he's just dropping his pants for no reason. And who knows, maybe that's one of his ways he gets his jollies, I don't know. But I wasn't going to allow him to do it if there wasn't a reason, a good reason to do it. Well, he was very upset after that. The jury came back, found him guilty. He wrote me several letters accusing me of appointing the worst lawyer in Brown County to pad my stats. Now, I don't know, I don't have like a football card or anything like that where I have me in a picture of my robe with my stats on the back or anything that is suitable for trading with your friends. So I'm not sure what stat he's referring to, but yeah, he wrote several letters accusing me of all kinds of things. And so based on the number of offenses and his failure to take any responsibility and just simply to blame everyone else for what he did, he got a lengthy sentence. And I thought about giving him something less than that, but the state's attorney, my intention was essentially to give him an effectual life sentence. And the state's attorney convinced me that you have to consider the precedent, of these sentences and make sure that, you don't just reduce the sentence down because that's all you need. And I decided he was right. I should just give him the sentence that I thought he deserved based on the crimes, and if it's too much, it's too much. But so I think he's parole-eligible after serving only like 80 years or something. So, and I think he's around 50-some, so yes. A lot of that issue is going to come from, I think in many ways Native Americans are treated more harshly, but I don't think they're treated more harshly in state court. I think they're treated more harshly in federal court. The reason I say that is that we have this weird relationship where we say, you know, we have these sovereign Indian nations, yet the federal government prosecutes these crimes, and they have, they're generally sentenced harsher in federal court because they don't really have any discretion. They have sentencing guidelines where, you know, and that's where they fit. You know, a state court judge, for instance, the young man I had yesterday, I could have sentenced him 1 day in jail to the rest of his life. We have a lot of discretion, and we don't have to try to as hard to fit a square peg in a round hole, where with the federal sentencing guidelines, in my opinion, they kind of say, here's the intersection and this is where you go, and it allows the judge a little bit of latitude, but not a lot, and the vast majority of people that are getting sentenced in federal court are Native American. So I think that that's one of the ways that I think Native Americans are treated more harshly, is that they end up in the federal system because of the crimes happening on the reservation. Yeah. I have an interesting, because he talked a lot about, one of the things that I found interesting / disturbing in the book was the fact that he made mention to this cap. I'm sorry, I can't look down. I have to read like this. He had this cap on court-appointed attorney guidelines or court-appointed attorney fees of $1,000. And so he talked numerous times about attorneys who later would be disbarred, and you know, it just seemed like these people that were going, you know, for really serious crimes, death penalty crimes, weren't getting very good counsel. And I wanted you to know, you'll be happy to know, that that isn't the case in South Dakota. The last case that we had that was a homicide case, it just went to trial. It was Judge Myron's case. He changed the venue, so they actually tried it in Pierre, or Fort Pierre. They appointed 2 attorneys to represent him. These would be attorneys that anyone would be happy to hire. They're some of our more qualified and experienced criminal attorneys. Now keep in mind, he said that, if I read it right, they had a cap on court-appointed attorney's fees of $1,000. So far in the Heminger matter, the county has paid the attorneys on his behalf $290,000. We haven't had an appeal yet. There'll be an appeal. We haven't had a first writ of habeas corpus, or a second writ of habeas corpus, or a federal writ of habeas corpus. In other words, this case is long from done, and we've already paid $290,000 to have these qualified attorneys represent him. And for the last 9 months, it wasn't a death penalty case. It was a homicide case, and he was facing mandatory life in prison, but it wasn't a death penalty case because the state had elected not to pursue the death penalty. Now, in fairness, for about half of that preparation time, it was a death penalty case, but then about the last half, I would say, it was not a death penalty case. This was an interesting case. Again, I talked about human drama. January of 2015, the victim is 26 years old. She's the mother of 3 children. She has 2 children with the defendant, ages 2.5 and 7 months, and an older child with another person. She is stabbed 23 times. I mean, it's about as gruesome, I won't even use the adjectives that they use to describe the scene to me. It's about as gruesome of a crime scene as you're going to hope to find. But as far as the system is concerned, what I want to make sure that you understand is no one kicked him to the curb. No one gave him the worst attorney in Brown County to pad their stats. They gave him very qualified attorneys and paid them a good deal of money to make sure that he had a fair defense at every turn. And I'm not saying that, again, I've never been a judge in Alabama. I've never been a lawyer in Alabama. So I can't speak to the author's experiences. They very well may be his experiences in Alabama. the things that I read in the book were very disturbing. I just simply couldn't believe that people would just so callously treat somebody else's rights in that manner. But I also want to make sure that you don't walk away thinking, yeah, man, the system's screwed, you know, nobody gets a fair shake. To me, I mean, I guess I would have, my first issue that I would have is with the judge that's named Robert E. Lee Taylor, or whatever his name was. I guess you can't control what your parents name you, but he's still going by Robert E. Lee, whatever his name was. That would be my first thing I would do, is take a motion out and recuse him from my case, because you can strike a judge from your case, and he's certainly not going to sit on my case. But, so that's kind of an example that was one of the more recent examples from our circuit. I asked the UJS, the Unified Judicial System, they have a person in charge of giving out statistics, and so I thought you might find this interesting as well. I don't know how many people are in death row in Alabama. It sure seemed like a lot. Since 1976, we've had 3 executions in South Dakota. We currently have 3 people on death row. So it doesn't seem like it's something that's being used a lot. We do have the option of sentencing to someone with life without parole. And that's something that I think is important, because that gives a judge an opportunity to say, I know this person won't get out, and I'm not subject to worrying about the parole board letting them out. We have an option of saying this person's going to stay. I think she gave me that. It has to be murder. So let's see. Currently on death row, Rodney Burgett. He was one of the people that murdered the R.J. Johnson, which is a correctional officer, and that certainly got a lot of press. Briley Piper, the torture and murder of Chester Allen Pogue. If I remember right, that happened out in the Black Hills or somewhere near there. His co-defendant, Elijah Page, was already executed for that matter. If I recall correctly, Mr. Page just didn't fight it. He said he wanted to be executed, and he just let it happen relatively quickly. And then Charles Rhines is on death row for the murder by torture of a store clerk during a robbery in 1992. So those are the 3 that are on death row. The 3 executions have been Elijah Page, which I mentioned, Eric Robert, who also was involved in the correctional officer Ronald J. Johnson, R.J. Johnson being killed, and then Donald Moeller, who abducted and killed a little girl by the name of Becky O'Connell back some time ago. And Mr. Rhines and Mr. Moeller was on death row for quite some time, and Mr. Rhines has, of course, been on death row since '92 or however long that trial took to play out, but you know, for quite some time. You'll often hear that it takes more money to execute somebody than it costs to hold them in prison for the rest of their life. And having been in the system, I've never done any kind of statistical analysis, but I absolutely believe that to be true. Having been in the system, when you talk about a death penalty case, all the rules change. The attorneys have to go, if you're going to handle one of these cases, the judge, the attorneys, even the court-appointed investigators have to go to death camp, which is a special camp, special training that they have to go to just to handle one of these cases. The rules are, you make every motion, whether it has any rhyme or reason or any chance of being granted. There's motion after motion after motion, things that normally a person wouldn't even think of. They make motions about because they have to dot every I and cross every T. So I believe that to be a true statement when they say it takes more to execute someone, it costs more to execute someone than it does to hold them forever in prison. Yeah. Yep. Mm-hmm. Sure.
But it seems like there's a lot more mental illness that's not being cared for in our society as a
Sure.
whole, and that a lot of people who are mentally ill end up in the judicial system. In fact, in the paper last week, 2 cases were on the headlines of people fleeing that they were.
Yeah. It's a significant issue, and so often the drug and alcohol abuse and mental illness go hand in hand. A lot of people self-medicate, so they talk a lot about co-occurring disorders. It's not uncommon whatsoever that those two things go hand in hand. And I know just a little bit about this. I served as the chairman of the board of mental illness for roughly 7 years, and so I was involved in the committal process, and really, it all comes back from, I think, what was good intended, which was the deinstitutionalization. Oh man, I can't say that. Not putting mentally ill in institutions. And I think that was, it was pure in its idea that you don't just put people, and lock them up forever because they're mentally ill. But what happened was, it appears that there wasn't enough support then back in the community. So really, very little is being done. Even when we would commit somebody on a mental health hold, which means when we're talking a committal, it means that they are, not only mentally ill, but a danger to themselves or others. So, it isn't just the fact that someone's a little off or a little colorful. I mean, these people this is serious. But basically what happens is a person, we would bring them to St. Luke's. They would have an evaluation. The doctor would say either yes, they're severe enough to go to Yankton, or no, they're not. They go down to Yankton, they regulate their medications for 5, 7, 10 days, and they send them back to Aberdeen. That's it. There isn't anyone that's making sure that they get their pill every day. There's certainly counselors, and they're doing what they can. But I never really understand when someone is on their medication and then they can understand that they need to take their medication because it's helping. I don't ever, there's some point where they stop. And why? When you're not on your medication, I get that you don't take your medication because you're not thinking right. That makes sense. But when you're back on your medication and things are going well and you've been doing well for a month, 2 months, 6 months, what happens then where it breaks that cycle where you stop taking your medication and now, it's not good and you don't have the wherewithal at that point to know that you need to take your medication. So it was very frustrating to serve as the chairman of that board because it really was, it was a revolving door. Send them down to Yankton and have them come back and just see them in about 3 months. We would deal with mainly the same core group of people, but just over and over again. So the mental illness issue is, it's always prevalent, but I don't know what the answer is. Yes. Yeah, we're definitely seeing a lot more languages. When I was magistrate, so we're only talking 10 years ago, I would have an interpreter hearing once a week, once a month, and usually Spanish. Now, regularly people are into court with speaking Spanish, Korean, Somali. One of the other judges told me the other day that they had to get an interpreter for Japanese, which was like, well, we don't. I was a Northern student, so I was not disparaging Northern, but there was someone who was studying abroad. So, but yeah, that was one that we don't see that often. But normally, what we do with that, we can get a live Spanish interpreter. There are quite a few people that speak Spanish, and so we do have a few Spanish interpreters available to us. Really no one that's a certified Korean or Somali interpreter. So what we have to use is what's called language line. And so we get on a conference phone, a Polycom, and everybody just sits around the phone, and then like I'll say a sentence and then they'll interpret it, and then the person will say a sentence and interpret it. It's a very cumbersome proceeding, and it takes quite a bit longer, but it seems to be pretty effective of getting the job done. Now, let's say we had this Heminger case, $290,000 for homicide. Let's add about 2 or 3 interpreters to that bill, because you'd need live interpreters, and they can't interpret all day long. They would have to switch out probably every hour, and you might need one that's interpreting just between the defendant and the attorney, and another one that's interpreting what the people say in the courtroom to the defendant. So, yeah, add some money to that. But we're getting by okay. But it is, Judge Anderson, who's the magistrate now, does have a separate session now just for interpreter hearings, and that would have been something that was unheard of 10 years ago. Yes? We do. A lot of times the self-defense cases don't go to trial because if there's a good self-defense, that's one of the things that the defense attorney and the state's attorney might take into account in working on some sort of deal that they can agree on. But we definitely do. 2 attorneys in my office today, they were trying to decide, I think we're set for trial in 2 weeks, and they were trying to decide whether or not this case should go to trial or not, and what kind of plea agreement this guy should get, and they were talking about self-defense and pulling a knife, but then the comeback was, yeah, but he had turned around by then and was walking away. And so, one of the things that I guess makes the defendants uncomfortable with self-defense is that self-defense isn't anything that the judge can help you with prior to trial. Self-defense is a factual dispute. So if someone tells me that I'm not guilty because of self-defense, they want to explain it to me, and they say, I understand, but I'm not going to make that decision today. The jury is going to listen to that and decide. They get to decide, whether or not you were in grave danger. They get to decide whether or not you used the right amount of force or if you went too far. That's all a fact question that the judge doesn't decide. That's what the jury has to decide. I understand it. They don't want to go to a jury trial. They don't want that uncertainty hanging over their head, but what if the jury finds against me? Maybe it's just a little better to take a little lesser plea agreement than roll the dice on the jury. But so that's where that would normally come into play, is if we actually went to trial. If the defendant has knife wounds or shots in the back, that's never good for your self-defense. Is there a hand up back there? Yeah. Yes. Depending on the degree, sometimes with developmentally disabled, there are some different programs that we can use that it's not saying that the person gets sent to the Department of Corrections, but they may be able to go to a specialty place, placement in Sioux Falls, or even go to Redfield, I think it's called Turtle Creek. So there are sometimes, if you have developmental disabilities to that level, but then the other ones that would be more challenging are ones that would be milder, that wouldn't really necessarily qualify for a placement, but still is affecting, their conduct. One of the biggest challenge for the juvenile justice system now is that they've taken a lot of the decision out of the discretion of the court. So, for example, I had a young man who had been sent to the Department of Corrections on a previous offense, and he's now back under, and the law has changed. He was involved with a number of other juveniles in vandalizing a property, the old Ramada Inn, and you may have read about that, I don't know. They did over $100,000 worth of damage. He's on DOC aftercare, which would, DOC aftercare, if you want to compare it to something in the adult world, that would be like being on parole. Okay, after you come out of prison, you're on parole. After you come out of DOC, you're on DOC aftercare. It's some supervision. Well, because of dual supervision, I can't place him on probation because he's already on parole. You can't be under the jurisdiction of the executive branch and the judicial branch at the same time. So I can't put him on probation. I can't send him to DOC because the law won't allow me to do that. So he's already been in DOC for serious crimes. He's back committing, I think it was a Class 3 felony, and I can't put him on probation, and I can't send him to DOC. What am I supposed to do with him? The law says I can send him to JDC for 90 days. So I send him to JDC for 90 days. That's it. That's all there is. Several of these other people that were involved in that, I order them to pay restitution. They get placed on probation for 4 months. If they pay me $0 at the end of the 4 months, I release them from probation. Nothing I can do. How frustrated would you be if somebody owed you $100,000, they got 4 months probation, they didn't even try to pay, and the judge just let them off probation? A lot of it is addiction. Again, that common theme going through alcohol and drugs, doing things because of you're intoxicated or because you want to get intoxicated. That's a theme. Hanging out with a bunch of knuckleheads. That's a theme. A lot of people that I deal with really don't have long-term consequences, no long-term planning. It's a lot of say, 4 people together. Which one of us is the dumbest? Okay, we'll operate on his level, and then we'll do whatever he wants to do. We won't think about it. No, heaven forbid that we think about it. We just operate. So, we have 100 IQ, we have 70, we have 60, and we have 50. We're definitely rolling on the 50, okay? That's how we do it. And then everybody commits these crimes. No one thinks about it beforehand, and then it's just a whole lifetime of, well, live for the now and we'll figure out the future in the future. So there's just not a lot of planning. I don't deal with a lot of people that are what I would consider evil. I mean, there's no boogeymen. I mean, if there could be 5 child molesters in this audience and you don't know. You don't know who they are. I mean, it's not like they look all that different when they come into court, once in a while. But, it's a lot of people who just make a lot of impetuous decisions that just don't think about the consequences, and they've never been taught to, and they just live for the now, and whatever happens, happens, and they deal with it later, and better to, ask forgiveness than permission. Was there a hand up out there, maybe just a stretch? Yes. It's not long enough. No, it's just not long enough. We don't know what the person is doing in 4 months. And here's a fun fact. The 4 months of probation, so I put someone on probation. The next day, they run off and go to Sioux Falls and do God knows what, and then 4 months and 1 day they come back, their probation has ended. Absconding from probation does not toll the probation. So if you don't want to be on probation, just run away outside of see if you can, stay free for 4 months without getting caught. And then when you come back, there's nothing that we can do because your probation's already done. 4 months just isn't long enough. So many people we're dealing with, we want them to go to treatment. That takes a while. After treatment, you want them to be in aftercare, figure out, is this working, or not, or go to counseling. Again, give them some time to work with the counselor. These are complex issues that we're dealing with. They're not going to be solved in a day. And 4 months just simply isn't long enough to figure out whether or not they're getting it and to monitor them. No. We did such a good job with juveniles that they closed the Brady Academy. I mean, it's the funniest thing in the world. They said, we don't need it anymore because we're doing such a good job. No, you changed the law. You don't let us send anyone there anymore. So you're saying that it's empty, we don't need it, but you changed the law so that no one's allowed to be sent. Did you have another thought, Aaron? Yes.
I heard a statistic once, or a fun fact once, that you can suggest the prison population in a place that looking at fourth grade reading level, and that at fourth grade reading level, their reading level, the prison population will be higher, and fourth grade reading level, and that's higher. Prison population will be lower.
My wife was telling me at supper today that the study that she was reading, and I can't tell you where it was even from, so I'm kind of just shooting from the hip here, but she said that by looking at kindergartners and their degree of social adaptation, they have some way that they measure those social skills. 1 point lower on the social adjustment scale, whatever they're using, will show like an 80% increase in population, homelessness, inability to get a job, being on government housing, all of those things, just by what social skills you have by the time that you're in kindergarten. So to me, I mean, if you're going to make any inroads, I guess you better start fast. Yes? Yes, definitely. And you deal with it however you can. You have to have a good sense of humor. You have to have good friends. You have to have a very fluffy white dog who loves you unconditionally. You do get sad, and sometimes you laugh and sometimes you make jokes, because if you want to just sit and bawl all day, I mean, I handled 6 cases of abuse and neglect today. That's on top of the 11-year-old girl that got digitally penetrated by someone who was a trusted friend of her grandmother, and among the myriad other things sprinkled in. I mean, if you want to bawl all day, you can. There's plenty of fodder. You don't have to make it up or pull nose hairs. You can cry if you want to, but you just have to deal with it. I mean, and the worst thing a counselor ever did to me was ask me how I feel. And I started bawling. Don't ask me how I feel. We don't feel, we just do. We have a job to do, and we go forward, and we do our job. We don't think about how it makes us feel, because that makes us sad. So we just do it. You do your job. You don't think about it too hard. But there are times when you just get down and you say, this day sucked, and Aaron, you're going to buy me a beer tonight. And he says, okay. Yes? Yeah. It's hard to say. I mean, I don't know. I mean, the theory, like I said, we're in the middle of a social experiment, and the theory now is that we've screwed everything up with the war on drugs and being too harsh. So now the current thinking is, is to pull way back and just treat everybody. It feels like maybe we're overdoing that a little bit and go, but this is what I know about working in the criminal justice system. If you want to think of a clock and a pendulum, this doesn't stop. It's here. We're too harsh. and then we're too lenient. And once in a while, we get right to the middle, but that's just by chance. I mean, even a broken clock is right twice a day, right? I mean, the pendulum swings. People say, that's it. Somebody went in and they robbed this old person and beat him up, and that's crap, and we're not taking it anymore, and we're cracking down. And then after a while, somebody says, no, that's not working. All we're doing is filling our prisons. We're just going to provide more treatment. And so then we try, I've already been around long enough to see it go back and forth. Right now, we're on a phase that we're pulling back and trying more treatment and less punishment. And like I said, it's a social experiment. I don't know what the answer is, and frankly, the people who passed the law, they don't know what the answer is either. In the middle of the experiment, you don't know. So. Am I taking too much time? Krista? Me too. It makes it so much easier for me. Okay, so you want to ask me any more questions? Then I'm going to share my funny letter that I got. All right. Yes? I mean, it's all linked. It's linked. I mean, it's generational. If people who are having a hard time breaking the cycle, that they were raised in a certain way without a lot of help, without a lot of intervention, it generally goes in a circle. And the thing is that what we're trying with DUI and drug court is providing that intensive intervention that we never had before and trying to break that cycle. But what I tell people all the time is that what I can't predict is motivation. And I try to, and the people who know me know that, I give analogies all the time, and that's just how my brain works. I have to sort it out. It has to make sense to me. And I think of it like this. I ran track, right? So if my track coach said, today you need to run 2 800s, 2 400s, 4 200s, and then, stretch and lift weights for a half hour, okay? That's what you need to do to be a state champion hurdler. Am I a state champion hurdler at that time? No. All I have is a plan. But I didn't do any work yet. That's what I need to do to be successful. That's my plan. That's what I can put up on the bulletin board. But I haven't done that work yet. And my coach, for no matter how good they are, can't motivate me. My coach cannot make me run until I throw up. My coach can't make me come back day after day. My coach can't make me want it. My coach can tell me, okay, you want it, but you don't know what to do. Here's the formula. Here's how you do it. But he can't make me a champion. I have to do that work. I feel the same way when I'm in DUI court, or really in any court setting. I can tell you what you need to do. I can show you the plan. I can give you access to these people that will help you, but I can't predict whether or not you have that internal motivation. I can't make you want it. If you don't want this for yourself, we're done. You have to want it. And that's the thing, is that do you get a glimpse of what a better life is or what normalcy is and say, I want that. I see that person right there. I want what she has. I like the kind of car that she drives, and I like the kind of house that she lives in. I like the way that she interacts with her husband. That's the kind of relationship I want. I want that. I don't know how to get it because I didn't grow up with that. But I want it. Help me figure it out. Help me, understand. And we can make them understand. Do they want it? Will they do the work? That's what I don't know. That's to me the key. There's a lot of people out there, for every time the probation officer says, I'm done with this person, it's time. They need to go. There's the probation officer that comes to me and says, yeah, Judge, I know they screwed up. I know you're tired of seeing them, but I can work with them. Keep them here. So there's so many people out there and so many resources that will help people if they want the help, but nobody wants to just get crapped on day after day after day. It wears you down. You know, it does. So, long answer. I hope that answered your question. It should have, because I spoke like 10,000 words. Yep. Yep. There's so many things that are interwoven. I mean, there really are. It's if someone, generally speaking, you know, a lot of it to me it comes from upbringing. You know, if you were raised correctly, if you were given opportunities and boundaries, not spoiled, but not just whipped either, if you were given both, you have a chance. Now, great people have come from terrible circumstances, but those tend to be the exception. With you know, if you have people that were given certain qualities as children, taught certain lessons, those kids will still go out and they'll still make mistakes and they'll still stray from the line, but they'll come back because they know what the line is. What if you never were taught what the line was? And you're just out there just trying to figure it out yourself. And it's education, and it's poverty, you know, and it's alcohol and drug abuse, and it's all connected. Anybody else? Okay, so this has some risque language in it, so if anyone wants to run for the hills, do so now. Okay, so I received this on October 7th from a man by the name of Dean Allen Cochran, who apparently is the defendant that I sentenced to 150 years in prison for sexually abusing his granddaughter, and the one that told me I set up the whole system against him, etc. Well, his cellmate decided to write me, or not even a letter, it's an affidavit. So bear in mind, he's the cellmate. He's in prison too, right? It is by my very nature that I must contact you to inform you that based upon my interaction with Jerry Lee Craig, that he is too stupid to have committed such a crime. And this is his buddy who's trying to vouch for him, right? So he goes on to say, I'll skip some of it. He says, you see, I qualify as an expert in such respects. I have actually been cellmates, with admitted child predators, and when a person speaks with a child predator, they know the truth about how child predators think, act, and you can clearly see it in their everyday behavioral patterns. Jerry does not fit into any of these criterion. It's kind of bad grammar here, but I think it says, truth is probably could not even get a hard on. And I have seen his penis in the shower, and it is rather small, almost non-existent, like a clitoris, but smaller. This is an affidavit sent to the court from this expert witness that's supposed to, I guess, help me see the error of my ways and release him immediately. Whoever it was that first said that Jerry Lee Craig is a child predator does not know Jerry. Jerry may be stupid, but being stupid is not a crime. Therefore, it is my expert opinion that there's been a manifest injustice that likely has resulted in the conviction of one who is actually innocent. His expert opinion. I wonder what he's an expert in. Obviously, again, I didn't put him under oath and make him say these things. He just sent this to me gratuitously. And I told my friends, if you ever have to say these things about me to try to get me out of prison, just leave me. Just leave me. Quit helping. All right, that's it. Thank you.